Greetings, Dirthlings. My name is Kenneth Trent, aka the Foreclosure Destroyer, and in today's episode of Stuff That Really, Really Needs to Be Fixed, we feature the litigation privilege. Check this out. When one is a criminal, engaged in a long course of criminal conduct as part of your daily activities, one ends up in court. This is as it should be, and it arises from the fact that there are certain phenotypes and genotypes of wrongdoing that our legislators over the centuries have become familiar with and have attempted to stamp out using the blunt tool of legislation. The legislation I'm referring to, of course, becomes codified in the Florida statutes. Examples of Florida statutes that are in place because of previously established and discovered criminal activity scams. You know, we've got our phylum and genus of the particular varieties of sperminiferous malditos. Anyway, but not to make light of the point, the litigation privilege. So, when you're a criminal and you've been doing XYZ for a while and somebody catches you, now the system has an opportunity to work as it is intended to do. And perhaps the victims can come to court. Even regular people can come to court with an attorney, tell the truth, and obtain redress for the wrongdoing that they happen to have suffered from this criminal, as this criminal is going about his daily, weekly, and monthly, and yearly business. As you probably know, the criminals I'm referring to in this context are unethical lawyers and bankers, servicers, the robo-signing phenomenon, the robo-witness phenomenon, the law firms that get busted for fake documents and taking people's houses without due process and then just enter into some kind of conditional guilty plea and get slapped on the wrist, and then you just change the name of your firm and put somebody else as the figurehead and keep on running the same racket. Yeah, it's that racket I'm talking about. So imagine, at any point in your long years of wrongdoing, you can be caught, and a particular victim of a particular moment of your particular criminal modus operandi has an opportunity to obtain redress. And that's true if you're on the street corner, in the library, discussing it in law school, college, the daily business world, if you're in the press, if you're in school. This idea that the justice system exists for a reason and that people have a fighting chance to actually get justice is well, part of the thing that really supports that, what we've got to have, is the ability to hold people accountable in court. Well, the litigation privilege does exactly the opposite. What do I mean by that? When you're your criminal going along in your criminal ways, the one time when you happen to end up in court because you're halfway busted, that's the one time you can continue to do whatever you want and nobody can hold you civilly or criminally liable. Say what? When you're in court and you do something wrong, like present a forged document, your punishment should be more severe than if you just present a forged document in a business transaction, although you can be held liable for that. This is why we have the Florida Consumer Collection Practices Act, the Federal Fair Debt Collection Practices Act, numerous statutes, okay? Racketeering, RICO laws, that kind of thing. These people, so when the legislature goes out there and says, listen, we know that debt collectors are scumbags, creditors equals predators, we are going to rein in these abusive collection agents. So they put these laws together as well as they can, all right? And yet, now, time and time again, when a litigant, a homeowner with a competent lawyer or without one on their own, catches fraudulent documents being presented in their foreclosure case, like all the ones that were presented by David Stern, and all the other law firms. There's Erica Johnson Stack, Cheryl Sammons, all of the really, really undisputed, totally discredited robo-signers. I mean, and this I see every day. When you've got a notary from Texas and your client has already contacted the Texas Notary Bureau and you have the certified records that say no record found, like the notary doesn't even exist, the notarization, like you've got them dead to rights. And that's when there should be a difference made. That's when there should be not another brick in the wall, but instead a fighting chance, a spike in the wall where the people can get some footing, and can actually, traction is the word I'm looking for. And no, not traction like this, that's what the banks need to be in, but anyhow, I ramble on, I digress. The litigation privilege is so outrageous. And so we must do something, because how can it be that the time that you're exempt for your wrongdoing is the time that it's most important when you're in court? Think about this, and if you get away with it while you're in court, then the judge grants something in your favor, like a final judgment of foreclosure in favor of a financial institution that does not exist. And at that point, you're just rolling. These bankers are rolling for years with fake modifications. They've got this property back in their clutches, and they're going to do an REO or a GED or a MVP or whatever. They are going to run some game on you like nobody's business. They are going to do the Wachovia Defeasance Series 2006 Legerdemain Backdoor Access Trust Series.com Inc. You know what I mean? Like, they just make up names. Every time they get caught doing something wrong, they make up names. And they're allowed to do that, apparently, in court. I tell you, that litigation privilege has got to stop. And I'll tell you something else. People need to come into court and actually identify themselves. I mean, when you've got somebody moving for a writ of possession who claims to represent Federal Home Loan Mortgage Corporation, when Federal Home Loan Mortgage Association actually was the party that was issued title, and then when you sue that law firm and say you have been presenting false documents from the beginning and you need to comply with the dictates of Florida Bar Ethics Opinion 29977, and instead of proceeding to obtain a writ of possession, you are required to stop things in midstream, do your ethical duty, go in front of the tribunal, that means the judge, and say, hello, there are some fraudulent affidavits here. You think? Now, when does that ever happen? Again, Florida Bar Ethics Opinion 29977. And so in this case, I'm telling them till I'm blue in the face. I'm sending them copies of the rule. I'm telling them, listen, guys, you don't even represent the title holder. Who the heck are you? And it's Douglas Zahm, and so I sue Douglas Zahm for violation of the Fair Consumer Collection Practices Act in Florida, and 559 of the Florida statutes, 559.72 and 559.77. These people actually claim the litigation privilege because they're doing this false documents in litigation. Somehow they're exempt from not being able to do false documents. Somehow they're allowed to do false documents, and we've chosen this particular time at which to allow that. This ain't recess, boys. This is court. And so to get back to the point that I was trying to make, when I sued Douglas Zahm, the next pleading I get in purporting to set a hearing and not noticing me, even though I've been counsel of record, going around me any way they can. Imagine this. Now it's EXL legal. EXL? Didn't they have a big and tall men's clothes like EXL or XXL? They went out of business? I don't know. So I'm like, EXL legal, judge, they're not counsel of record, they haven't substituted in, their notice of hearing is a nullity, they didn't coordinate with me, although they purport to have served it on David Stern, who was the attorney for the bank 3 and 4 years ago. He's still on the service list, but I'm not. So, and they're still traveling on the fraudulent assignment of mortgage, and they're moving on behalf of the wrong party, and the judge is going to give them a writ of possession, and then I go over to circuit court and I sue, and Douglas Zahm says litigation privilege. No, that has got to stop. Don't you think? Thanks for listening.